man-made missiles was once unprecedented in the West Bank. Now it is routine. Mr. President, members of the court, Israel's victims are often children. They include 5-year-old Ruqayya, who was shot in the back by Israeli forces on January 7th at a military checkpoint in the West Bank. Her body was withheld from her family by Israeli forces for 10 days. Just last week, Israeli forces also shot 16-year-old Nahil in the head, killing him as he was leaving school. Nahil was the 100th Palestinian child killed by Israeli forces in the West Bank since October 7. This brings me to the fifth practice implemented by Israel, which is its discriminatory military legal system in the OBT. This system privileges Jewish Israeli settlers while depriving Palestinians of the most basic legal protections. A pillar of this system is the practice of indefinite administrative detention of Palestinians without charges. As we detailed in our written statement, this practice was widespread before October 7. Its use has increased excessively since then, in what some rights groups have characterized as mass enforced disappearances. In the past 4 months alone, thousands of Palestinians have been placed in administrative detentions. In Gaza, they are rounded up, blindfolded, disrobed, humiliated, and detained in makeshift outdoor prisons. You can find detailed reporting at tabs 5 and 6 of your folders. In the interest of time, I will not detail the 3 remaining policies and the practices that characterize Israel's occupation, which are discussed in Chapter 2 of Qatar's written statement. These practices are 6: the eradication and suppression of all manifestations of Palestinians' culture and religion in the OBT. 7th, the economic oppression of Palestinians and the exploitations of the OBT's natural resources. And 8, the systematic persecution and suppression of all those who attempt to document or pursue accountability for the occupation, such as human rights organizations and journalists. This includes Al Jazeera, Shireen Abu Akleh, who was murdered by Israeli forces on May 11, 2022. Mr. President, members of the court, these 8 discriminatory practices and policies are among those that the court is called upon to assess in answering question A. Viewed jointly, they reveal the true nature of the occupation as an illegal settler colonial regime. I will turn now to the final portion of Qatar's presentations concerning the legal status of the occupation and the response to question B. Mr. President, member of the court, the written statements and comments that addressed in question B overwhelmingly endorsed a finding by the court that the Israeli occupation of the OBT is illegal. This was the express conclusion of at least 38 participants in these proceedings, with at most 2 states reaching the opposite conclusion. Those participants finding that the occupation is illegal offered a number of lines of analysis to support their shared conclusion. This is unsurprising. Israel's occupations has violated so many fundamental principles of international law that it would be hard to point to just one reason for its illegality. In Chapter 3 of Qatar's written comments, we identified 5 main reasons as to why Israel's occupations of the OBT is illegal. With its written comments, Qatar also submitted a detailed appendix compiling relevant statements by participating states and organizations. These can be found at tabs 7 to 15 of your folders. We hope that Qatar's analysis will be helpful for the Court's work. I shall briefly walk the Court through 5 reasons for the illegality of the occupation. First, the occupation controversies the jus cogens obligation to respect the right of self-determination of the Palestinian people. 39 states and international organizations found that the occupation violates the right of self-determination. 28 of those participants underscored that the occupation has become illegal for this reason. Second, Israel's occupation also violates jus cogens prohibition of apartheid. 25 participants endorsed a finding of apartheid. Among those reaching this conclusion, 16 participants underscored that the situation of apartheid renders the occupation itself illegal. Third, Israel's occupation is illegal because it violates jus cogens prohibition on the use of force. This was the conclusion of 18 participants. Fourth, by virtue of its illegal annexation of portion of OPT, Israel has breached yet another jus cogens norm, the prohibition on the acquisition of territory through the use of force. At least 41 participants in the proceedings have pointed this out, with 31 of them underscoring that the occupation is illegal as a whole because Israel's annexation of the OPT is an integral feature of the occupation. Fifth and finally, Israel's occupation is illegal due to the fact that it's not of a temporary character, not being carried out in good faith, or not being administered in the best interest of the occupied population. 17 states reach such conclusions. Mr. President, members of the Court, the State of Qatar endorses all of these arguments for the illegality of the occupation. While it's, of course, for the Court to decide how best to answer the General Assembly's questions be, it is Qatar's respectful submission that the Court should not limit itself to choosing only one of these grounds for illegality. Unlike contentious cases, judicial economy does not support the adoption of only the narrowest reasoning possible in these proceedings. To the contrary, in the context of an advisory opinion, the Court's function is to provide legal advice to the organ requesting the opinion. There are multiple relevant legal regimes applicable to the situation, and the Court's advice on each of these frameworks will be of immense value to the General Assembly and to the international community at large. In this connection, Qatar and many other states attach particular importance to a finding that Israel's occupation by its nature amounts to a regime of apartheid. A finding of apartheid is not just the most accurate label for what the occupation has become. It also provides a tangible but a flexible roadmap for what must come next. What ending apartheid requires is achieving a situation in which all people, Israeli and Palestinians, equally enjoy their fundamental human rights and dignity. With the requisite finding of apartheid by the Court, the international community, including the General Assembly, can activate similar mechanism for bringing about an end of the occupation as it did with the apartheid regime in South Africa. This is the surest path to truth, justice, and yes, reconciliation. Mr. President, members of the Court, the people of the world are looking at you. We are confident that you will seize this historic opportunity to finally bring to an end a century of injustice against the Palestinian people. I thank you for your kind attention.
I thank the delegation of Qatar for its presentation, which brings to a close this morning's hearing. The court will meet again this afternoon at 3 p.m. to hear the United Kingdom, Slovenia, Sudan, Switzerland, the Syrian Arab Republic, and Tunisia. The sitting is adjourned.